Good morning, good afternoon, or good evening, depending upon where you're joining us from. My name is Hawley Johnson, and I'm the Associate Director of Columbia Global Freedom of Expression. Thank you for being here today for what promises to be a fascinating discussion of the Cambridge Handbook on the Right to Freedom of Thought, edited by Patrick O'Callaghan and Bethany Shiner. It's really a groundbreaking volume that critically examines the right to freedom of thought across national and regional legal frameworks. And although freedom of thought is enshrined as an absolute right in the universal system, it remains one of the least understood in legal practice and scholarship. But this book takes on that challenge, with contributions covering 18 jurisdictions, chapters on the regional systems, and thought-provoking analyses of contemporary issues such as online disinformation and neurotechnology. We were inspired to organize today's webinar after watching an excellent book launch at the Bonnevero Institute for Human Rights at Oxford University. Our aim today is to build on that foundation and take a deeper dive into how the regional systems specifically are interpreting and giving effect to this right, particularly in light of rapid technological change and the global rise of authoritarianism. The webinar will run for 90 minutes, and we've divided it into two panels. In the first, the co-editors will present the overarching goals of the book, its methodology, and its broader relevance for contemporary legal scholarship and practice. Reflections will then be offered by Ahmed Shaheed and Lautaro Furfaro. The second panel will focus on the regional human rights systems, with authors and discussants reflecting on doctrinal and contextual dimensions of the right in Europe, the Americas, and Africa. Closing remarks will be given by Nazila, Ghanea, United Nations Special Rapporteur on Freedom of Thought or Belief. Please do share your questions in the chat. We're going to try to address as many as we can in light of the time constraints. For any we can't get to, the authors have kindly agreed to provide written responses, which will be posted on our event page and in our newsletter. The webinar is being live streamed on YouTube, and a very special thanks to the support of Jolie McPhee and ISOC Live. And they're going to stream it again in the coming days and have it archived on their website. And I'm also super pleased to announce that the publisher has generously provided a 20% discount code for anyone interested in purchasing the book. And that is available on our event page. So now let me briefly introduce our first panel. And again, I'm just going to give a very brief intro with the titles because all of the information is available on our website. Bethany Shiner is Senior Lecturer in Law at Middlesex University and co-editor of the volume. Patrick O'Callaghan is Professor of Law at University College Cork and co-editor. Their presentations will be followed by commentary from Lautaro Furfaro, Senior Legal Researcher at Columbia Global Freedom of Expression and Professor of International Human Rights Law and the Philosophical Foundations of Human Rights at the University of Buenos Aires. Ahmed Shaheed is Professor of International Human Rights Law at the University of Essex and former UN Special Rapporteur on Freedom of Religion or Belief. And he engaged with the book's research during his mandate. With that, let's begin. Bethany and Patrick, the floor is yours.
Thank you, Hawley. Thank you. We are very honoured to have been invited to launch this handbook with such a prestigious human rights institution. So thank you very much for all the organisation that has gone into it, and thank you to the discussants and all the attendees for making time for it today. The handbook was a real pleasure to work on with Patrick and all of the contributors. I will give a little bit of a background to the handbook and briefly try and situate it in the current literature on the right to freedom of thought, and then Patrick will talk you through some of its main findings. The right until recently has been overlooked for various reasons. It was assumed to be symbolic and without any real utility. For how can someone violate your right to freedom of thought? No one knows what you are thinking, and no one can force you to think in a different way. Attempts to change your thoughts fall under the protection of other rights like the prohibition of torture, and of course the right to freedom of expression protects your right to express your thoughts. Another reason it is overlooked is that even when we do recognise that governments, religious institutions, militaries, corporations and so on do try to change our thoughts, and that thoughts have long been persecuted and punished. The problem with the right to freedom of thought is that we are not sure how to define thought, and we are not sure how wide the freedom is. We are not sure how to demonstrate a violation, and thus we are not sure how to protect it. Furthermore, a wide definition of thought, so that it may include almost all of our mental activity, if not all of it, including emotions, could make it unworkable, because much of our daily civic duties require us to honestly disclose our thoughts as a witness, for example. And this is where arguments for a threshold standard come in, which some of the chapters in the book address, meaning that a violation would only be established if that threshold is met, although there are different ideas on what the threshold indicators should be. In the literature, freedom of thought was previously referred to in terms of rational thought and reason, and therefore the notion of freedom of thought formed parts of arguments advocating for public education or in defence of the scientific process, for example. But then in 2010, there were constitutional philosophy literature on freedom of thought as an autonomy-based theory for freedom of speech by Professor Schifrin. And then, in 2014, Christoph Bublitz published an article on freedom of thought, followed by Susie Allegre's 2017 article. And these were the first times that freedom of thought as a human right was plucked out for closer examinations. So the interest that those articles generated, combined with the technological developments in AI and neurotechnology, which together offer a more concrete illustration of how the right could be violated, has helped interest in the right grow over the past few years. Much of this contemporary literature takes a philosophical approach to understanding the nature of thought, the distinction between the internal and external aspects of thought and thinking, or seeks to work out how the right to freedom of thought would differ from other rights, like the right to mental integrity, mental autonomy, cognitive liberty, privacy. Neuroscience research, of course, cites the right, but without much development, as a legal claim. So Patrick and I thought that there was a gap in knowledge, which we thought to address by examining the jurisprudence internationally. We were curious about whether legislators and courts have already made determinations on the contours of the right, what it protects, how, what the normative tools of interpretation are, and what are the associated state obligations. We wanted to know whether domestic and regional courts are already engaged in some of this work. And so the handbook tries to fill this gap by documenting and analysing domestic and regional approaches to the right, which often had not been written about before, or at least not in English. Another purpose of the handbook was that we wanted to expand the perspectives on the right to freedom of thought by diversifying literature beyond the dominant North American or Western European approaches. And so we invited scholars from other regions to engage with the right, sometimes for the first time. As Hawley indicated, the book is split in three. The first part provides our editor's analysis, and then we have a chapter from Christoph Bublitz on the drafting background of the Universal Declaration of Human Rights and the International Covenant of Civil and Political Rights. The main bulk of the book, though, is the second part, composed of country reports from 18 different countries in the regional systems in Europe, the Americas, and Africa. The third and final part of the book provides some critical analysis of the right, for example, in the context of digital manipulation or discrimination, or problematizes the distinction between internal and external thought. We asked authors of the country reports to consider the scope of the right in the jurisdiction they were writing from. We asked them whether it was absolute or qualified, the history of its inclusion, its philosophical roots, how it interacts with other rights, and the context of its application thus far. So the local context was very relevant when considering how the right is interpreted and the circumstances it might be applied in each different jurisdiction. The authors of the regional chapters, who will present their findings today, examined the relevant regional treaties and the case law arising from the regional human rights courts specific to the right to freedom of thought. It was a bit of a risk to delve into the project of trying to systemise how jurisdictions protect and have interpreted the right. The risk being that there would not be much to report other than this jurisdiction also incorporates the ICCPR, but no case law has come before the courts on the distinct right and so on. However, there were signals that we would uncover more than that, and thankfully we did, which Patrick will tell you about. But of course, the right still remains underdeveloped. But now we hope that there is enough to offer scholars and courts substantive guidance for further development of the right, which courts, legal practitioners and scholars can work with. I will now pass to Patrick.
Good morning or good afternoon, everybody, or perhaps even good evening. I'd like to echo Bethany's thanks to Columbia Freedom of Expression for this opportunity to present some of the main findings of this study. I'm going to arrange my remarks under three broad headings: scope, content, and source of the right. And I'm going to start with source. One of the things that interested Bethany and me right at the beginning of this study was that there's something of a paradox when it comes to the right to freedom of thought. In popular discourse, especially discourse on social media, the right features prominently, with users frequently invoking it in political debates, for example, which might lead the average person to believe that the right is one that is protected across the world, or at least in democratic legal systems founded on the rule of law and human rights. But here, freedom of thought is often used as a synonym for freedom of expression. And in fact, when you take a closer look at the legal systems across the world, you find that only a minority explicitly mention and seek to protect freedom of thought in the positive law of their domestic legal systems. In our study, the right featured explicitly in the constitutions or high-level legislation of approximately a third of the legal systems in our book. And this tallies with other comparative studies of the right. Felicitas Benziger has examined the constitutions of all Council of Europe members and finds only a minority recognize the right. Interestingly, a clear East-West divide here, with more legal systems in Eastern Europe recognizing it. At the same time, the lack of explicit reference to the right does not mean freedom of thought remains unprotected. In one legal system, for example, in Colombia, the right does not feature in the constitution or legislation, but has been recognized and developed by the Constitutional Court in a very sophisticated way. In other legal systems, there may be no reference to the right in the constitution or high-level legislation, but the right becomes part of domestic law by virtue of the state's obligations under international law. In other legal systems still, even though there is no distinct right in domestic positive law, freedom of thought is understood to be an underlying value of the political legal order. That's the case in the United States, for example, especially in the context of free speech. It's also the case in India, where freedom of thought is mentioned in the preamble to the Constitution as an underlying value. In other legal systems, freedom of thought was not recognized as a distinct right, but the country reporters argue that other rights in domestic law safeguarded or could be stretched to safeguard the core components of freedom, for example, in Germany. And what all of this means is that there were only 3 legal systems in our study where we did not find any meaningful legal references to freedom of thought, and they were China, Vietnam, and Malaysia. So to sum up, even though a minority of legal systems surveyed explicitly protected freedom of thought as a distinct right, the right nonetheless features in different yet meaningful ways in the clear majority of legal systems we examined. Content. Some of those legal systems where a distinct right to freedom of thought is recognized, courts have sought to elaborate what the content of the right is. This is very sophisticated. I mentioned Colombia earlier. The Constitutional Court there draws a fundamental distinction between the positive dimension of the right and the negative. The positive dimension is a right to develop one's thoughts autonomously and to freely adopt and live by any ideology, philosophy, or cosmovision. The negative dimension is that the state, and interestingly, third parties, should not access or discover a person's thoughts without their consent, should not coerce them to think in a certain way, nor can they interfere with an individual's cognitive processes, which includes compelling a person to reveal their thoughts. In Japan, we find a somewhat similar approach, though there seems to be less emphasis on the positive aspect. And there, the Constitution guarantees both the protection of thought and conscience. And the courts often use the collective term inner freedom to describe the interests at stake here. Other noteworthy approaches to the content of the right include a number of African legal systems. As Sfiso will explain later, the right is not explicitly mentioned in the African Charter, but it does feature in the legal systems of several signatory states. In Zambia and Mauritius, for example, the right is understood as an aspect of freedom of conscience. Interestingly, the constitutions here provide that no person shall be hindered in the enjoyment of this freedom. And this verb to hinder is a fascinating choice. On the one hand, if a state has a duty not to hinder the right, it might be argued that this implies a duty to at least facilitate freedom of thought. On the other hand, the reference to hindering would seem to represent a lower threshold than alternative verbs such as to infringe or to interfere, in respect of the point at which freedom of thought becomes engaged. And in this context, one could imagine all sorts of complaints coming before the courts. However, the right to freedom of thought in Zambia and Mauritius is a qualified right, and interestingly, the relevant provisions expressly state that a person can consent to their freedom of thought being hindered, all of which makes it more difficult to successfully claim that freedom of thought has been hindered in the first place. Finally, on scope, as Bethany mentioned, there seemed to be something of a consensus amongst our authors that while the right to freedom of thought is an absolute right, this does not mean that absolute protection extends automatically to all rights. The Japanese reporter summed it up as follows: the right to freedom of thought is not as broad as including all mental activity of the inner realm, yet not as narrow as only guaranteeing religious beliefs. The consensus amongst our country reporters seemed to be that we need some sort of de minimis threshold. Now, this might lead to some skepticism. If a freedom is protected absolutely, how can we talk about de minimis thresholds in the first place? But in practice, even when rights are understood as absolute, courts tend to apply such thresholds. The author of the German report gives an example. In dignity under the German Constitution is protected absolutely, but that does not mean that all behavior that treats other people in undignified ways merits the attention of the law. Rather, there is a de minimis threshold where the intrinsic value of the human being is denied as a matter of principle and absolutely. We know a violation of dignity when we see it. And likewise, we can say that not every potential interference with freedom of thought will merit the attention of the law. Our authors provided different suggestions on this front, as Bethany explained, but it's also the case that we should recognize a violation of the right that crosses the de minimis threshold when we see it. That's it. They were some of the main findings of our study. Thank you for listening.
Thank you so much, Bethany and Patrick. I found your chapter fascinating, and it really made me think about the need for almost like a typology or taxonomy of the right to thought, because as it's evolving, particularly in the sphere with neurotechnologies, and that would be almost required in order to get a better handle on the different thresholds that would need to be developed in order to protect it at various stages. But anyway, I'm sure that's going way deep into the weeds. I really look forward now. We'll pass the floor to Lautaro, who can provide his commentary.
Thank you very much to the team at Columbia Global Freedom of Expression, and especially to Holly Johnson and Stephanie Mulali for the tremendous work in organizing this webinar. And of course, congratulations to Bethany and Patrick and all the authors on this extraordinary book. And thank you for presenting it here at the Columbia Global Freedom of Expression academic community. One of the greatest strengths of this book for me is the diversity of its contributions, drawing in different regions, legal traditions, and both domestic and international perspective. But I speak from a very concrete role. At Columbia Global Freedom of Expression, I map the global legal conversation and jurisprudence on freedom of expression, and I also teach international human rights law at the University of Buenos Aires. So from that perspective, my comments adopt only an international focus on the book with emphasis on the three regional levels, which is also the vocation here we have at Columbia. The starting point of the handbook is both simple and ambitious, to take seriously a right long recognized but hardly ever developed, and to test it against technologies and practices that make its violations thinkable and possible. Contemporary challenges of freedom of thought were not imagined by the drafters of the Universal Declaration in 1948, the European Convention in 1950s, the ICCPR in 1966, the American Convention in 1969, or the African chapter in 1981. So for decades, the forum interum seemed unreachable, but today neurotechnologies and algorithmic systems can profile or steer mental processes. This, I feel, creates urgency, well met by the book, for a comparative map that goes beyond philosophy and connects the remedies and the legal standards. In the chapter of European system written by Felicitas, the paradox is clear. Although Article 19 of the European Convention explicitly recognizes freedom of thought, case law is scarce and often shifts towards conscience or religion or other rights, but the book contribution is to affirm that sort of autonomy of freedom of thought and to suggest practical ways to make it operative. In the Inter-American system, the paper written by Bethany and Claudio, the chapter shows a significant turn. For a long time, freedom of thought was treated as a part of freedom of expression under Article 13 of the Convention. Today, however, there are, according to the authors, solid grounds to recognize it as an independent right. The regional debate, which I am part, now links it with data protection, privacy, and the impact of artificial intelligence and neurotechnology on personal autonomy and democratic deliberation. In Sfiso's chapters on African system, the picture is different. The charter, as Patrick explained, mentions conscience and religion, but not thought. And the drafting history is limited. Still, the chapter reconstructs implicit protections through the charter's structure and practice. Three elements from a common core: no punishment for thinking, no interference in mental processes, and no compulsion to reveal or adopt thoughts. So all in all three regional chapters understandably focus on the role of the state, since human rights treaties were basically designed to restrain public power rather than private actors. Yet today, the reality of this right is disproportionately shaped by corporate practices, a gap that opens a pressing need for future research. With this in mind, I only want to mention two more comments. First, remedies. If a core is absolute, what we do once interference happens or occurs? We should think about sort of restoration, corrective notices, algorithmic unlearning, presumption in favors of the affected person, structural measures to rebuild autonomy. I don't know. Second, evidence or thresholds of evidence. What matters is the method and intensity of the influence, the asymmetry of power, the duration of repetition, the decisional context, and the degree of self-determination affected by the victim. So finally, allow me to add a Latin American nuance. I am from Argentina. Our region has been quite creative in expanding rights through principles like pro persona or the conventionality control, constitutional courts. Patrick mentioned Colombia, but there are many others, have offered valuable insight into mental autonomy and inner forum. This experience can help ensure that the right to think does not remain abstract, but becomes relevant in litigation on manipulative information practices, biometric surveillance, and so on. From Buenos Aires, where I teach, this agenda does not feel theoretical or distant, but quite urgent. So to finish, I want to close with a simple conviction. The handbook is not just an atlas, it is an invitation to build a shared language for a freedom that sustains many other rights. And in times of technological acceleration, and especially here in Argentina, civic fatigue, taking freedom of thought seriously revitalizes the protection of privacy, dignity, autonomy, and of course, freedom of expression itself. So I believe this is the most powerful contribution of the volume, and the challenge it leaves us to researchers, scholars, teachers, mappers, litigators in this field every day. Thank you.
Thank you so much, Lautaro, for expanding on the complexities of getting a better understanding and protection for it, especially as it relates to so many other rights. And now with that, I think we can hand the floor to Ahmed, who can share his reflections.
Thank you very much. First of all, thank you, Columbia Global Expression, for inviting me. It's a real honor to join you on this important occasion. And also congratulate the editors and the authors of this extraordinary book, as the previous speaker said, on the book's launch. Having worked at the UN for about 6 years as the person in charge of protecting the right to freedom of thought, conscience, religion, or belief, was quite thrilled when I heard about the book being published, especially because it brought together some of the best experts in the field for both the conceptual chapters as well as for the country assessments that were included in this. Then, of course, the book also covered a vast number of jurisdictions, and something which was missing at that point was really assessment of how the right was protected on the ground in these countries. And also, rather than just number of countries, there's also very carefully across regional or rather multi-regional in its coverage. So really a very comprehensive look on the ground on how the right was protected. And of course, it covers both conceptual elements. The book is bookended by the conceptual elements of the chapters in between focused country reports. I was quite struck by what the book actually exposes. It exposes how little we actually know about the freedom of thought. I think other speakers have already spoken about this, but also how differently in different country contexts we understand it. Of course, as I think Bethany and Patrick's chapter highlights, there's also disagreement as to why we defend the right. For some, it is a sense of personhood. For others, thoughts are non-volitional, therefore it makes no sense to punish people for thoughts. But again, showing the diversity of approaches to the thought. Then again, if you see at the UN context, we think of Article 18 on freedom of religion as the nearest, if you like, a right of freedom of thought. But in the inter-American system, it's linked to the idea of expression. Again, that distinction also exists. If you look at more deeply into the right, about the interconnecting rights, we think of privacy very quickly. We also think of education, and also I think we should think about culture as well, because it's again a variety of forms through which the right can be approached or understood or certainly constrained. So the vastly different ways of understanding it, of approaching it, was very striking to me. In terms of what it offers a structured way of examining how this right can be approached, not just conceptually, but also in different country contexts. So you find a common thread running through the different chapters, engaging on a structured focus comparison, as it were, of how different attributes of the right are protected or not protected in different contexts. The result, therefore, is a very nuanced assessment of the issues concerned. And one of the most striking debates that come from the book is the question of forum internum and forum externum. On the one hand, as an absolute protection in the forum internum, that does arise with really absolute. Can we really afford to make it an absolute protection? And then, of course, at the other end, where we have the forum externum, where the presumption has been that the rights are always qualified or can be qualified. The question does arise whether or not freedom of thought in regard to the extended mind thesis does not deserve absolute protection. Again, these are very difficult questions. I don't have an agreed view on this by the authors here. But again, these are very useful and important questions to engage on as to how these are protected. One theme that comes out of the book, and in the end, a proposal it makes is that perhaps the qualification for absolute protection should be reserved for those that just the test of cogency, coherence, importance, and seriousness. That's where I think consensus now lies. I am not exactly sure if it will remain that way, but I think, again, the book opens a prospect that we need to engage on this aspect as well. And then, of course, the book's importance has already been highlighted. Emerging technologies is one of the key drivers here. I remember as a young person growing in the 70s, an old, now Nobel laureate Bob Dylan line, "If my thought dreams could be seen, blah, 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 blah." Now, of course, the theme part was never going to be, at that time, real to me. But of course, if my thought dreams can be seen, they put mine in the guillotine. It's a very real thing today. It's happening, I think, in many ways. So I think the emergent tech has really made this rights examination and understanding very, very significant. Then, of course, as one of the chapters really also make it clear in the end, the growing inequality in the world and how this also impacts on our understanding of freedom of thought. Not a very direct link here, but if you look at the chapter there, you will see how the fight against discrimination, how the fight against hate will have touch upon the extent to which one's intent has to be identified, and to the extent that may or may not actually infringe or might require an assessment of one's thoughts. Again, these are all open for debate, but again, highlighting the importance of this aspect of it at the present time. And then, of course, like I said, rampant hate. The idea of a hate crime was intent. Again, I'm not convinced that we need to actually get into the forum internum here. But again, in terms of justice, that's an important element. The point I'm referring to here is actually the breakdown, as it were, of the basic framework within which the UDHR was proclaimed. As in Article 1, the belief that everyone was endowed with reason and conscience, and now we come to a point where people behave without reason at all, and that at what point does that actually then maintain the framework as it is? Also, when the basic idea of human rights coming out of mankind being shocked to the conscience by events that happen in the world. Again, if we are unable to really respond with our conscience, then what do we do with the protection we've grounded on those? I'm not saying anything is off the table, but again, these sort of situations, the erosion of rights, make the very core right, essence of the freedom of thought, one of the founding elements of personhood, examine more deeply. Of course, I approach this from the perspective of freedom of thought for free thinkers. That's again, ongoing issue. Also, securitization. Increasingly, the counter-terrorism project is based upon trying to pick people's motivations upstream. And the higher up you can go, the better, which means, of course, even before you know for yourself, you're thinking something that you might do in the end. So again, the protections for this become very, very important. For me, the ultimate value of the book lies beyond all the debate is the potential to operationalize the protections for these rights. To operationalize a protection, a right means, first of all, we must know the attributes of that right. What are we trying to protect? What are the elements of that right? Then followed up by what are the ways in which, what are the institutions required to protect this right? Then, of course, ultimately, when will we know when the rights have been violated? The indicators of rights violations or protections. I think the empirical, the country reports in this volume offer the opportunity to really delve deeper into the attributes and to the indicators that are required for this work. I want to salute the editors and the authors for this very important work. And I'm sure that for years to come, we'll be engaged in developing this and debates that come out of this. I look forward to that from everybody. Thank you very much.
Thank you so much, Ahmed, for sharing your personal experiences. From your perspective and the work that you've done, you've really seen how this right is evolved in light of the current challenges and how difficult it is on the international system to advance protections. So I think out of the interest of time, I'm going to move on to the second panel right now. The second panel is on the international human rights systems, and we're going to start with the Inter-American, where I'm going to turn back to Bethany Shiner, who is the co-author of the chapter on the American Convention on Human Rights. And then after Bethany's remarks, Lautaro Furfaro will respond as discussant. So Bethany, I hand it over to you again.
Thank you. This chapter was co-authored with Claudio de la Vida Santos Colnago, who can't be here today. He's now gone into private practice. I'm going to give an overview of the system of protection provided to the right to freedom of thought under the American Convention on Human Rights and within the Inter-American system. I'm going to point out some unique features for comparative purposes, given Felicitas will discuss the European system and Sfiso the African system. Our chapter presents the protection of the right as developing in 3 stages. The first stage being prior to the creation of the Office of the Special Rapporteur for Freedom of Expression, and in this part we focus on the Advisory Opinion 5 of 1985. In the second stage of the Article 13's development, we look at case law after the Office of the Special Rapporteur was created, which is 2001 onwards. And then the third stage we discuss is an emerging and possible new conception of the right to freedom of thought, which we suggest could find its basis in the pro-homin principle under Article 29b of the Convention, and we see as being further bolstered by the 2023 Inter-American Declaration of Principles regarding neuroscience, neurotechnology, and human rights, which singles out the right to freedom of thought. So, as an overview, the Inter-American Court has not yet had a case before it, or at least not at the time of writing the chapter, to test the scope, limit, and application of a distinct right to freedom of thought, possessing an internal dimension. In other words, the forum internum, what is within our minds. Yet there is still much to say, and our argument is in the chapter is that freedom of thought should be developed as a distinct right with an internal dimension. And so, as many of you will know, Article 13 of the Convention protects the right to freedom of thought and expression and the right to access of information. So, in that way, it's different from the Universal Declaration of Human Rights, the European Convention of Human Rights, and the International Covenant on Cultural and Political Rights. And those 3 treaties all couple freedom of thought with freedom of conscience and religion, and then separately, under different provisions, protect freedom of opinion and expression together. So often, as we've already heard from previous speakers, the elements of thought and opinion are understood as internal aspects, the form internum, and the expression or practice of religion or belief is the manifestation in the external world. But under Article 13, we could not detect any substantial acknowledgement of that internal aspect. The external aspect, however, is defended in the strongest terms because of the role free thought, expression, and access to information has in creating and preserving democracies and safeguarding against authoritarianism. Another unique feature is the fact that Article 13 contains a dual or double dimension, meaning that there is an individual and collective dimension to the rights within Article 13. It's a feature of the Convention I find very inspiring because it recognises that an individual's inability to exercise their rights under Article 13 has a compounding effect on society at large. So the people who would otherwise benefit from that individual exercising their rights are also rights bearers. The advisory opinion 5 referred to the individual dimension of freedom of expression and the dissemination of ideas and information as indivisible concepts. The corresponding right to receive information or receive the output of someone else's expression protects the reciprocal nature of open communication in democracies because there is a collective interest in receiving different opinions, information, knowledge, etc. But here it is implied that thought formation, which of course is influenced by receiving different opinions, information and knowledge, does fall under the protective remit of Article 13, even though that is not made explicit. Another characteristic of Article 13 I want to point out is that it is not absolute, meaning that if we consider Article 13 as containing 3 rights, distinct, separating thought and expression, and then thirdly, information, the right to freedom of thought, unlike under the European Convention on Human Rights, unlike under the ICCPR or the Universal Declaration of Human Rights, is not an absolute right. But its limitation is subject to the strict boundaries of subsections 2 to 5 of Article 13, including necessity and legality. So it can be subject to limitations, but the cases establishing Article 13 as non-absolute have not actually considered directly the internal aspect of thought. So we can continue arguing otherwise. The context of dictatorships engaged in widespread and gross human rights violations at the time the Convention came into force in 1978 is highly relevant to the interpretation and application of the rights within Article 13, as well as the other rights within the Convention. And the Article 13 rights have protected journalists from persecution, ensured the independence of media outfits, prevented prior censorship and propaganda, established the need for the state to release public information as a way to deal with corruption, and acknowledged the right to truth for victims of forced disappearances. It is essential also for the electorate to exercise its political rights, and as such, the state has a positive obligation to enable the dissemination of information, ideas, and opinions. And here we can refer to Article 13's innovative position on countering media monopolies. So one reason that the court has not had an opportunity to consider freedom of thought as a distinct right is the facts of the case before it, particularly during this second stage of development of Article 13, where there were numerous cases addressing the terrible legacy of authoritarian rule and the specific egregious human rights abuses that arose from it. In other words, the development of Article 13 has been confined to the facts of the cases before the court. But I do think that this legacy of abuse of power and all the components that allow it to happen is relevant to how the right to freedom of thought could take shape in a third stage, particularly the notion of non-commodification of brain data and the protection of dignity, integrity, and autonomy from abuse. So although the Inter-American system is alert to the issues raised by neurotechnology, there is some pressure placed upon the current contextual interpretation of Article 13, given that the court conflates thought and expression together. The court does adopt an evolutionary approach, so it may be called upon in time to determine how Article 13 would apply to neurotechnology. And there's already a lot of literature in this area, for example, from the International Network on Neurolaw and Human Rights and the academics within that network. So how might the Inter-American Court respond to such proceedings? Well, there was nothing that we could detect in the case law that would make it difficult for a distinct right to freedom of thought to be understood with an internal dimension to evolve from Article 13. Such an evolution could and must retain the dual dimension, but the court would have to grapple with the question of whether and how Article 13 protects the forum internum as well as the forum in externum. And unfortunately, the court would not find much inspiration from the European and African systems on this specific issue. But the inter-American human rights system has been more progressive in many areas, and there are some tools at its disposal already, which may help, including the pro hominem principle I mentioned before, which ensures that the dignity of the individual is of primary concern when interpreting convention rights, and it ensures no provision is interpreted as precluding other rights and guarantees inherent to the human personality. This means that rights can be enumerated by the court, and it would fit with the fact that Article 13 is recognised as a deeply interconnected right linked to other rights, including Article 5, right to humane treatment, and Article 11, the right to privacy, with that right to privacy acknowledging dignity, social identity, and personal autonomy, thus relaying back to the need for the Convention to be interpreted as one complete harmonic document. Freedom of thought, after all, is a necessary precondition for the effective enjoyment of other rights. When looking at what Article 5 and 11, as well as the principle of habeas data, which is the right to access one's own data, told us, is that thought is partially and sometimes indirectly protected under the Convention. But the protection of thought would sometimes fall into a grey zone of non-protection. Here, the Inter-American Judicial Committee passed a non-binding resolution that I mentioned earlier on the Inter-American Declaration of Principles regarding neuroscience, neurotechnologies and human rights. And that declaration does appear to seek to shrink this grey zone of non-protection because it refers to freedom of thought as a standalone right, independent from freedom of expression and as distinct from conscience. So my final concluding comment is simply that it appears possible to us to develop a regulatory approach whereby freedom of thought is developed for harmonious application to scientific and technological developments, but not limited to, under the Inter-American system of human rights. Thank you for listening.
Thank you, Bethany. That was absolutely fascinating and really, I think, such a precise discussion of the situation in Latin America. And it really helped me understand how they can have such an incredibly rich jurisprudence on freedom of expression, but yet it's the protections for freedom of thought are not yet so clear. But Lautaro Furfaro is next, and he's going to provide some commentary, and he has extraordinary experience in these areas. So thank you, Lautaro. Please take over.
Thank you, Hawley and Bethany. Thank you for your presentation and for the chapter written with Claudio that, in my view, marks a before and after in the Latin American conversation on freedom of thought. I would like to share a few reflections and then ask you some questions, even when there might not be time for live answers, but maybe we can open our weekly newsletter for you to share your thoughts if you have time and you wish to do it. Well, first, a comment on the diagnosis of the chapter. The chapter takes Article 13 of the American Convention seriously and shows that the inter-American practice, thought and expression have been treated almost as one and the same, reducing thought to a mere precondition of expression. The dominant line has reinforced the dual individual and collective dimension, the link to democracy, and the centrality of public debate. Yet, the inner forum has remained conceptually underdeveloped, and your work and Claudio's work reopens that doors with a convincing blend of comparative, historical, and doctrinal analysis. The trajectory of inter-American case law and the framework you reconstruct are persuasive and highly useful, for future litigation or learning, or for young scholars like me when teaching. So, second, a comment on the proposal of the chapter. If we recognize that freedom of thought is a right distinct from freedom of expression and the right to information, this implies, I think, in concrete obligations. For instance, I am speculating avoiding manipulative design, ensuring genuine consent, protecting neural data, and safeguarding the integrity of our mental processes. As you explained in the chapter, this is not entirely new ground. In 2023, I think, the Inter-American Juridical Committee adopted principles on neuroidentity and integrity and the prohibition of manipulation and algorithm and so on. But the key question is, for me, how we give these right clear contours without draining content from other rights of the chapters. One idea is to work with a clear thresholds, as you mentioned, for serious interference, combining factors such as opacity or extreme asymmetry of power, techniques aimed at conditioning or blocking inner deliberation, and real impact on personal autonomy in meaningful decisions like health, voting, work, association, and so on. And my third comment is about the remedies. If the violation occurs in the mental sphere, post hoc and purely individual remedies might not be enough for victims. We need remedies adapted to this type of harm, rapid and effective, corrective notices, a right to traceability, an audit of model, algorithmic and learning of cognitive profiles, transparency in behavioral experiments, and structural measures to protect attentional environments. This, I think, connects with the Inter-American tradition of transformative remedies. Moreover, monitoring compliance should measure two things: a reduction in manipulative practices and a real improvement in people's ability to make informed decisions. So I don't have much time, but two more comments from the South. Let me add another nuance. I have reviewed the entirely jurisprudence of 50 decisions under Article 13 in the Inter-American system, and that is why I especially value the clarity which this chapter organizes that body of jurisprudence and suggests a much needed conceptual gap or leap for the Spanish-speaking audience. It is important to stress neither the recent Oxford University Press commentary edited by Hennebel or Triudhar, nor the very well-known Conrad Adenauer manual by Bertoni, Salazar, and Celada address freedom of thought under the convention with this level of detail. And this book fills a genuine gap and opens an agenda for strategic litigation, neurotechnology regulation, legal standards, and of course, legal research within the Inter-American system. I would like to add a practical suggestion in our region. As Bethany also mentioned in the book and in her presentation, the special rapporteurship on freedom of expression has been a driving force in setting standards, it could now take a step further by creating a focused line of work on freedom of thought and neurotechnologies, and this could mean drafting preventive guidelines, supporting key test cases, and working with data and authorities of the domestic jurisdictions. Such an initiative would translate chapters insights into concrete regional practice. So to finish, I would like to close with two interrelated questions for Bethany. First, I think you answered this, but you argue that Article 13 actually contains three distinct rights: thought, expression, and information. When these overlap with, for instance, Article 5, integrity, or Article 11, privacy, will you favor a lex specialis approach toward Article 13, or rather like a double door model that activates positive obligations simultaneously under those articles, Article 5, integrity, 11, privacy, and 13, freedom of expression? And the last question, more important, I think, in the short-term regional context, what do you see as the most realistic structural remedy for pilot cases where the right of thought might be violated?
Thank you so much, Lautaro. We've got lots to think about, and I think we're definitely going to keep a close eye on the inter-American system for some of the more interesting advances in protecting this right. And I'm sorry, Bethany, we don't have a ton of time for you to respond. If you wouldn't mind providing a written response, then we can definitely post that on the website. We'd like to move on to the European system now, and we're going to introduce Felicitas Benziger, the author of the chapter on the European Convention on Human Rights. And Felicitas is a postdoctoral researcher at University College Cork, and she will be followed by Brian Frenkel, who will offer his reflections. Brian is professor of the European and African human rights systems at the University of Buenos Aires. So, Felicitas, the floor is yours.
Thank you very much. Since I don't know what time zone everyone here is joining from, I will just say hello, everyone. It is great to be here in this virtual space to talk about the right of freedom of thought. And to start with, I would like to extend my thanks, of course, to the organizers of this event for inviting me to speak about my chapter. Just one note ahead. I don't know if that saves much time, but instead of saying European Convention on Human Rights every time, I will just say ECHR to keep things short and concise. Also considering that I think I have at most 8 minutes to briefly outline the key points of my chapter, which is what I shall attempt to do now. Obviously, there is quite a bit of substance and nuance, which cannot be reflected in such a short talk, but I hope that my brief intervention will efficiently illustrate some key ideas. So the question around which I framed my chapter is whether the right to freedom of thought can be considered a right of independent legal value in the ECHR, or whether it is rather to be interpreted as an ancillary right. Ancillary here meaning to other more specific rights that focus on forum external manifestations of what the right of freedom of thought may cover, which I consider in my chapter a pure forum internal right. Now, in the chapter, I start by illustrating the historical background of Article 9 ECHR, that is the provision providing for the right of freedom of thought. And I explain how the ECHR was modeled after the UDHR, that is the Universal Declaration of Human Rights, and how initially Article 9 was only envisioned to cover freedom of religious belief, practice, and teaching. Then only in the course of the data drafting process and under the notable influence of Pierre-Henri Teitgen was the wording of Article 18 UDHR, the provision relating to freedom of thought there, reproduced in Article 9. So importantly, I outlined the historical background, namely the experience of two devastating world wars and the start of the Cold War, as being part of the context in which one must interpret the background of Article 9 ECHR. And put differently, probably echoing something that was said in the introduction earlier, when I explain that I research on freedom of thought, I am often confronted with the reaction that we are free to think anyways. So how is the right to freedom of thought legally applicable or even necessary? And there is truth in that. In fact, there is an old German folk song which contains a line that can be translated into English as "Thoughts are free, who can guess them?" And that song became popular in times of revolution and political upheaval. Basically, it encapsulates the idea that regardless of external pressure or restrictions, our inner worlds are always free and untouchable. Now, if it was that simple, this is where my presentation, including my research, could end. However, even the drafters of both the UDHR and the ECHR deemed it necessary to state that, presumably, obviously, namely, everyone has the right to freedom of thought, conscience, and religion. And this said, it is true that in practice, the right to freedom of thought often sits behind what can be considered more specific provisions, particularly Article 9, Paragraph 2 ECHR, so the practicing of religious beliefs, and Article 10, expressing opinions. And this invites the question of whether freedom of thought is a right of practical applicability and distinct value, or rather, whether it should be understood as a symbolic right. And this question becomes even more significant if we consider that the European Court itself stated that the Convention is designed to guarantee rights that are practical and effective, not just rights that are theoretical or illusory. Considering this, the natural starting point appears to be to try and define what a thought is. In other words, what is the content of Article 9, Paragraph 1, and how, if at all, does it differ from the other rights mentioned in the same provision, namely freedom of conscience and freedom of religion? In my chapter, I start by proposing that thought could just cover all beliefs that are not of a religious nature. However, what speaks against this is the different terminology as such. So if thoughts and beliefs are the same, then why do the Convention, the Court, and even the drafters use separate terms? And then secondly, belief has its own definition given by the Court and is practically applied to spiritual beliefs or personal worldviews more broadly that do not fall strictly under religion. Since the adoption of the European Convention, it seems that there has only been one case in which the then European Commission on Human Rights seemingly determined what falls under the category of thought under Article 9, and that case is Salomon versus Finland from 1997. In that case, parents claimed that the refusal to register their name of choice for their child constituted, among others, a violation of their right to freedom of thought. Now, the case was eventually dismissed, but the Commission did acknowledge that considering the comprehensiveness of the concept of thought, this wish can be deemed as a thought in the sense of Article 9. So wishes, at least as far as they concern the choice of one's child's name, can be considered a starting point for what could constitute a thought following that approach. Beyond this, the right to freedom of thought is best understood as the root of all unmanifested specific forum exterm expressions, such as opinions, the practicing of religious and other beliefs, but also as an essential aspect of a person's inner private life. And I argue that if we understand the right to freedom of thought as the organic basis, of course in a metaphysical sense, from which all manifested thought recognized in other parts of the Convention emerge, then it is unthinkable to apply specific sets of requirements to determine what constitutes a thought. In fact, the very rationale of freedom of thought could very well be to maintain a protected space for a person's inner cognitive processes, free from any outside judgment or interference. And this also correlates with the absolute nature of the right as recognized in scholarship and jurisprudence. And I believe I have to come to an end at this point in my chapter. I also elaborate on other points, including state obligations that arise from the provision, its nature, possible limitations. But for now, I will just quickly return to my initial question of whether the right of freedom of thought is to be interpreted as having independent value or whether it is better understood as an ancillary right. So in a nutshell, legal practice so far has been embryonic. Applications have sometimes been partially based on the right of freedom of thought, But there has not been a single case yet before the European Court of Human Rights where this was the core or the only provision claimed. Additionally, claims related to the right of freedom of thought have so far only been considered either in conjunction with other rights or in a supplementing fashion, or engaging with the right of freedom of thought in substance has been avoided by the respective body. However, on the other hand, the drafting history does not support a reading of the provision as ancillary, and nor does the terminology of the convention itself. And also considering the significance, as I illustrate in my chapter, it does not support a reading of this right being ancillary necessarily, especially if we consider freedom of thought as the very cornerstone of being human, if we follow the spirit of cogito ergo sum. So I think, therefore, I am. And I will end on this note. Thank you very much for listening.
Thank you so much, Felicitas, for giving this great comparison to the inter-American system. And I'm going to just request that everybody keep their remarks to the preordained time because we are running a little bit over. Thank you very much.
Good morning and good afternoon and good evening to everyone. And I would really like to start by thanking you, Hawley, and Lautaro, and all the Colombian Global Freedom of Expression team for the invitation. As you know, I've been invited to discuss this chapter on the European system by Felicitas, who we have the pleasure to just listening to. And I want to start by thanking the editors for preparing this book. It looks really, really interesting. I have the opportunity to go through it. And particularly Felicitas for a very interesting chapter and for sharing some important insights on how these freedom of thoughts work within the European human rights system. I have to start by saying that one of the things that I like a lot about the chapter is how well organized it is. It's very clear how to follow the path of the reasoning from her. And it guides us onto the conclusion and remind us of these key questions that she's posing there. It's very well organized, and I really enjoy following that path that you proposed. What I also would like to highlight is that you, Felicitas, normally the first thing that you do initially is present two key issues that appears when considering freedom of thoughts under the European Convention. The first one is the relationship between freedom of thoughts and freedom of religion and belief. And the second, and you highlighted this as well, that it appears to be a matter of the inner realm of a person's identity, this forum internum, and the other speakers also refer to this. And if it's that, then it seems to be beyond the legal regulation. Felicitas, to do this, what she does is she focuses only under Article 9 of the European Convention, and she presents that article, as she explained, by providing the historical background on how it was drafted, how it was included there. But then she also follows to discuss the content, the scope, what is supposed to be this article. And she relies on very scarce jurisprudence on the matter by the European organs. But then she goes back and says, okay, these are the contrast between these freedoms and what we need to consider, the challenges that we may face when studying this right. In the section presenting the historical background, I like the comparison with Article 18 of the Universal Declaration of Human Rights, and that you also made a difference that even considering that there was a change when it was drafted the European Convention, they added a second paragraph that was not included there, so that already makes a difference. And also this drafters discussion, the key element that they thought to add another element, and that they were adding this freedom to protect specifically persons and shielding them from forced conventions or torture. So I like this idea that the clear conclusion here is that freedom of thought goes beyond protecting something that is beyond only religion. So I think that this is something important to clear, to keep that here. And then in the next section on the chapter, I think that is the most interesting questions that arise when considering this. What is the freedom of thought under the European Convention? And this discussion of whether it is an independent right or is an ancillary one, and what is the meaning of this? If it's independent, what it means, and if it's an ancillary one, what happens here? And I think that you made a point on why is it important, because you explained the definitions by the European Court on what it means if it's an independent right or an ancillary one. But you don't keep it as a theoretical discussion. I think that your chapter does very good on explaining what happens if we consider it as an ancillary right, and then that will happen is that it will come to depend on the fulfillment of the requirements of other rights. Like freedom of expression or religion, before we even consider the freedom of thought. And then you focus on the different language that are referring there, different terminology with freedom of religion and belief, freedom of information, freedom of opinion. And I think that gives an idea to push us to think specifically what does it mean then, freedom of thought. And for me, as a reader of the chapter and also as a professor on the matter, it was great because it forced me to go beyond and think specifically on the meaning of thought, the value that it's protecting, and the importance of protecting it. And I think that was one of the key issues on your chapter that I really enjoy and actually trigger a lot of questions for me. And for me, then the idea is that although there are different freedoms that are mentioned under the same provision, they are there for a reason. And then if we want to have an European Convention that is going to be effective, then it's important to recognize the intrinsic value of each of the freedoms mentioned there and understand which aspect of our individuality they're trying to protect. And I think that you help us to understand that. And I think that it's imperative then to have this proper understanding of the content of this right. So each actor can play the role that they have. Individuals can enjoy the freedom, but then states can comply with the obligations and the courts can understand how to adjudicate on the matter. And I think that that's important. And I think that probably that's where so far the European Court has failed a bit on daring to deal with this provision, even when they had opportunity. In the text, there are some key concepts there. And again, this is the idea of this forum internal of the person that you highlight that it's reinforced, at least in the European Convention, because it's the one that is not mentioned on the Article 9.2. And the other freedoms are mentioned there. So it means that they're actually not focusing on the manifestation of this external element. And then you mentioned some of the cases, but you go through those cases, and I like some of the conclusions that you drew from there, that this is the idea of thought may coincide with belief, but when it's not religious from this jurisprudence, but it's also a separate thing from the freedom of religion and belief. As you mentioned, wishes, certain wishes, like the name of a child, may be specifically recognized as a thought there. That there is a clear protection against indoctrination, and that I think that it's interesting that you actually are there to explain that European organs actually avoided the references to thought. Even in some cases, they may have the opportunity to do it, but they avoided that, either referring to formal requirements or because they resolve the matter without the need to address that other part of the possible claim that they have. So I try to put together some of the key issues that I see from all that section. And for me, it's that the idea that an absolute protection provided to the forum internum actually doesn't help us to understand what it is, freedom of thought, under the European Convention. But yet, these relevance of the distinction of the two forums, the forum internal and the forum external, are vital to understand it. So I think that that's one of the key takeaways from here. And that then the very rationale of the freedom of thought is to maintain this protected inner space. And I like that you refer that as a foundational precondition to other related rights. And I think that was important. That was the food for thought that I took from there. Then we needed it for other rights. And I like when you refer in those cases of lex specialis, if they apply, it doesn't mean that actually they don't have this autonomy that you referred before. It's clear that the European Court has taken some shortcomings and some missed opportunities. But then, as you understand on the chapter, you mentioned on the chapter, there are other elements that you refer to: potential applicants, to limitations, to derogations. And I think that you disagree with other authors that it is actually absolute, and you even refer to a peremptory norm that comes from there. And then you refer, then what do we do with this looking forward, and what are the challenges that are coming on that? So for me, the takeaway from your chapter is that, apart from a very interesting discussion of whether or not it's independent or not, what we have to understand is the foundational value that it has to play with the other rights, and that's why we need to do that. And I like that you're optimistic and you believe that the system is ready to deal with that. I hope that it will come to happen soon. And a lot of the questions that arise when I was reading it, and I understand that you will refer to them after, comes from thinking, okay, if we understand that, if we try to focus on that, then what do we do with new challenges, new technologies, that I think that it's a common thread along the book. But then, for example, what is the role of disinformation or misinformation? Because it misguides persons and how they think. Do the state have an obligation to deal with that? What happens with children? Because it's the parents the ones that are representing them. Do they have their own agency to address those kind of rights? And I think that it's important that given the current state of affairs in the world, we really need to think about that. And I really believe that your contribution is very welcome for that, because it gives me already something to think, and I'll make sure that it's added to the bibliography on my courses. So I really thank you for that, for the opportunity to participate today. Thank you.
Thank you both so much. And I know there was a range of questions that you would hope to get to. So I hope that you both will also contribute some questions that we can answer in writing and post later on in our website and in our newsletter. So I encourage everybody to, one, put additional questions into the chat. We've already received a few. We'll make sure they do get answered, and then make sure to sign up for the newsletter. We're going to move on to the Africa system now. We are running a bit behind. So I thank you all for your patience, and I'm going to introduce now Sfiso Nxumalo, who is going to share insights from his chapter on the African Charter on Human and People's Rights. Sfiso is reading for a Doctor of Philosophy in Law at Oxford University. And the discussant on this panel is Caroline James. She is one of our senior editors here at Columbia Global Freedom of Expression, and she's also the Advocacy coordinator at the AmaBhugane Center for Investigative Journalism in South Africa. So, Sfiso, the floor is yours.
Thank you very much. I will be exceptionally short, hopefully no more than 2 minutes, precisely because of this. So the African Charter is a little bit of an oddity in the sense that it does not have an explicit right to freedom of thought. It has freedom of education, it has freedom of expression, it has freedom to receive and impart information, but bizarrely, there's no right to freedom of thought. One would think that freedom of thought would be there if there is a right to expression and so forth, because, you know, it is the sort of foundational seed that gives rise to the fruit of other rights, but it just is absent. Now, you would then think that you could find something in the drafting notes. You could look back and find in the previous iterations whether or not freedom of thought was ever conceived of. But again, perhaps unsurprisingly, there's nothing there. And this is despite the fact that in the previous drafts, they had actually explicitly stated that they're going to take motivation from the international covenants, which actually do have the right. So it's not really understandable why it is missing. And this is why my discussion is relatively short, because there's really not much jurisprudence to deal with. What actually emerges is that the closest thing that you could get is Article 8 speaks about freedom of conscience and the freedom to sort of practice and profess a religious belief. So with that as your standard, you can basically try to read in and try to get an implied right to freedom of thought. And that's exactly what I try to sort of do in my article. I basically look at how the courts have interpreted Article 8, and usually it's in the context of like political beliefs or the context of religious belief. And then I try to sort of say, well, if that is the starting point, we can then add on a few other rights, such as the right to freedom of expression, freedom to receive information, and so forth, to then construct this implied right. But the oddity of the absence of the freedom of expression is exacerbated by the reading of the African Children's Charter. It's just basically focused on kids. There is an express right to freedom of thought. So this creates the impression that when one gets to the age of 18, before that, you have the right to freedom of thought. But as soon as you turn 18, at the stroke of midnight, you no longer have freedom of thought. Now, this is inexcusable and unexplainable. So in my view, that then lends more to the argument that there is an implied right. And that implied right is bolstered by the fact that there is no explanation as to why a child should have the right to freedom of thought. But then as soon as you become an adult, you don't have that right anymore. There's a illogical sort of jump there. So the logical solution is that it must continue. And then there's the Maputo Protocol, and effectively the Maputo Protocol is meant to cater for women's rights specifically, and there as well, there's no right to freedom of thought. But I also try to sort of construct that looking at various other rights. With that being said, and in light of the time, I will bow out. I think I kept to my promise of being relatively short, and hopefully there's something that you gleaned from that short presentation.
Thank you so much, Sfiso, for a very concise summary. And Caroline, I'd like to invite you to comment.
Thank you very much, Hawley, and thank you, Sfiso, for your really interesting chapter. I really enjoyed reading it and engaging with the questions. You spoke at the beginning of the chapter about the question of freedom of thought in Africa being a mare's nest and the confusion and the complexity that it involves, and I think that that's a really apt description of it, particularly also when we think of the connotations behind a nest, about it being the origin of rights and sort of the foundational element of a number of other rights. I think it's, as I said, it's just a really apt way to set the scene for your discussion. I think what I'd also like to do is build on the sort of optimism that Felicitas and Brian mentioned. I think we could all do with some optimism at the moment. And I have seen in my work in various African countries how so many of these interrelated rights, freedom of expression, freedom of the right to protest, all have these sort of histories of a colonial experience of suppressing thought and suppressing dissent, and how those colonial era laws have been used in independent African governments to continue this sort of suppression of opposition. But what is quite positive is that there is a movement towards shifting this. And we can see that quite recently in Malawi with them decriminalizing criminal defamation. So I think that we can take heed from that and see where the African systems can provide opportunities to expand the rights, to develop it. Sfiso mentioned how there is no set right, but it's very interlinked within rights within the African Charter, but also in those sort of subsidiary treaties and conventions and in the Maputo Protocol particularly. And I think one aspect that I really appreciated in Sfiso's chapter was the focus on the protections and the rights given to women and children in Africa. And I think that that's relevant for two main reasons. Firstly, we all know that Africa is the youngest continent. 70% of sub-Saharan Africans are under 30. And so there is a need to focus on the rights of children and youth and their participation in political thought and political development. And then, not that this is unique to Africa by any stretch of the imagination, but there is a history of gender discrimination and sort of hindrances given to women's participation in political and decision-making, intellectual development, the rights to sort of development of personality. And Sfiso really highlights how the Maputo Protocol protects those rights, which can then be used as a way to demonstrate that there is a sort of underlying freedom of thought protected within the African human rights system. So, as I said, I want to try and end on a positive note. And I think that what this chapter does, and the book in general, hopefully will give impetus to African lawyers who are litigating in these areas around the continent, both before domestic courts, but also before the regional and continental tribunals, that we can use the rights that we have to try and expand it to include the right to freedom of thought. And in this post-colonial, post sort of, I don't know what type of post we are in the world at the moment, but we understand that there's a pressure on human rights all around the world. But perhaps this is an opportunity for Africa and African lawyers to use the areas that Sfiso has highlighted to really push forward and maybe take on a sort of a leadership role in this. And one of the reasons we're able to do that is because of the focus in the African system on those vulnerable groups of youth, children, and women. So I think I will close there, but want to thank Sfiso particularly, but everyone else as well. This has been a fascinating discussion to witness and to be a part of.
Thank you so much, Caroline, and thank you, Sfiso, and thank you for that sort of optimistic view. I think the one thing we've really taken away from here is that we really do need collectively to pay greater attention to the right to freedom of thought and development, and develop clear standards in response to these unprecedented threats that we're facing right now, which is the convergence of the neurotechnologies, the digital environment, and the democratic backsliding. But now that have all of this wonderful work done in the book, I think we have a path forward. And with that, I'd really like to pass the floor to Nazila Ghanea, the United Nations Special Rapporteur on freedom of religion or belief, for her closing remarks.
Thank you very much. In the interest of time, please accept my thanks to the hosts, to the excellent authors, and editors. But let me move on with the key points I wanted to address. And it was clear from the discussion in this webinar that some of the critical observations of the handbook will no doubt continue to be debated well into the future. So on sources, on thresholds, on the positive and negative dimensions and protections and the sources. So much has been discussed about in this book. I want to welcome that much has been discussed about the distinctiveness of freedom of thought. But I'm going to be a little bit parochial and focus back on freedom of religion or belief and ask what freedom of thought can bring and how it can enrich our understanding of freedom of religion or belief. There are perhaps at least three obvious ways in which it does so. One is that already the book has stimulated, as several of the panelists addressed, deeper scholarship on the forum internum and, of course, on non-coercion, that there should be no coercion in relation to this inner realm. So your scholarship has already advanced that. And secondly, about freedom of religion or belief in times of technological innovation, as Lautaro put it, and which Ahmed's report, for which I warmly thank him, in this mandate really contributed to and advanced. And thirdly, in relation to freedom of thought and the profound dangers encapsulated in violations of freedom of thought for religious and belief minorities, including non-believers, the very crushing of diversity can be facilitated by the violations of freedom of thought. And regrettably, there are many states that would be very much in favor of that. So let me move on to other ways in which further scholarship, and I really hope you can update this handbook every 5 years. I think it would definitely be merited, and I can help make the case to Cambridge for you as well to reinforce that. But what are some other ways that freedom of thought scholarship can help and contribute to freedom of religion or belief and our understanding and protection of freedom of religion or belief? Well, these relate to the inner deliberation and in thought and belief formation and religious and belief belonging. So not just assuming the belonging, not just belonging by way of inherited belonging, but the inner deliberation that upholds the person's continuing belief. I think Sfiso's point is very apt here in that why is it that we understand it in relation to children? I mean, the Convention on the Rights of the Child talks about the spiritual protections for children, but we don't have any other human rights treaties that uphold it for us after we stop being children. What about really ensuring a free environment of exploration, discussion, and examination of religion or belief matters? What about addressing informed decision-making in relation to religion or belief and countering manipulation and ensuring that interpretation is understood as being part and parcel of freedom of religion or belief? So whilst I welcome all the scholarship that is talking about distinctiveness, moving it more into the realms of political beliefs and non-religion, I still think developments in scholarship and jurisprudence in this area will also challenge us in some of the presumptions we have around religion or belief belonging, that somehow the individual's own deliberation and thought is not so essential to it. I think it will help challenge that and ensure also full freedom of thought, conscience, religion or belief across all four of those grounds. Thank you.
Thank you, Nazila, so much for joining us today. We're really honored to have your perspective. And I just want to thank everybody for joining today, and thank you to all the speakers. Please do check back on our event page for follow-up materials and responses to unanswered questions, and sign up for the newsletter so we can continue this discussion going forward. Thank you again.